Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about how to modify an existing child support order. We did an article, a podcast, and a video blog about changes to Illinois child support law that are going to go into effect on July 1st, 2017. And we had a question about whether you could modify your existing child support order based on that new law. So this podcast and video blog is kind of a response to that comment. And if you have any further questions about this or any other podcast, video blog, or article, please leave a question in the comment section and we'll answer it with our next article. So we have a new law coming down the pipe on July 1st, 2017, and it's going to change how child support is calculated. The question was, can I modify my existing child support order based on this new law? The answer is that you can, but it's not that simple, because the law itself isn't a basis for changing your child support order. In order to modify your child support order in Illinois, you need to demonstrate a substantial change in circumstances. And a change in the law in and of itself doesn't constitute a substantial change in circumstances. But if you can, after July 1st, 2017, show that you've had a financial change in circumstances or some other change in circumstances other than the law, then when you have your child support modified by the court, the new law will be what's used to calculate your new child support order. So if you can get back into court on your child support after July 1st, 2017 by showing a substantial change in circumstances, you can have the new law applied. And if you want to learn more about what the new law is, go to learn-about-law.com, and we have a video and a podcast and an article all about that. And lots of people have been reading it and asking questions, and that's kind of why I'm going down a child support rabbit hole. So first I'm going to talk a very little bit about how to modify a child support order before I go into what constitutes a substantial change in circumstances. So the important thing to know is that a child support order can only be modified by the court. You can't modify it by agreement of the parties. That's a little unintuitive because you think if the recipient of the child support agrees to a reduction of child support, or if the payer agrees to an increase in writing, then that's good enough. You don't have to pay attorneys and go back to court. Unfortunately, any out-of-court agreements are not enforceable unless they're ratified by a court order, because the court is the entity ultimately responsible for looking out for the best interests of the child. So they need to authorize any agreements between the parties. You also can't use self-help to modify your child support. So if the person receiving child support isn't holding up to his or her end of the bargain, not allowing you the visitation time that's required in the court order, you can't just withhold child support until they comply with the court order. You can go in and seek sanctions from the court for contempt of court for failing to comply with the court order, but you can't use self-help to just reduce child support as the situation changes. You have to file a petition for an increase or reduction of child support and serve notice by regular mail 30 days in advance of the hearing of that petition on the recipient of the child support, or the other side of that petition. So let's talk about the basis for going in and modifying a child support order. You can't just, like I said, based on the new law, say, I want my child support order changed to comply with this new law. You have to show a substantial change in circumstances first. And let's talk about what counts as a substantial change in circumstances. Unlike a lot of things in family law, this isn't determined by statute. The court has a wide discretion to determine what is a substantial change in circumstances and what isn't, but they use case law to determine the precedent as to what types of situations are substantial changes in circumstances. So one substantial change in circumstances is an increase or a decrease in the payor's financial ability to pay the child support. This seems pretty intuitive. So it's things like getting a raise at work, or losing your job, or even voluntarily reducing your pay or terminating your employment, or going to school rather than being employed, if you can show that pay reduction or employment termination is in good faith and not for the purpose of reducing child support. So you're not trying to evade child support, you're doing it with the hopes of making more down the road. Similarly, with the change in circumstances of the person receiving the child support and their financial ability to care for the child, if they have an increase in their pay, then that might reduce the child support obligation of the person paying child support. If they have a decrease in their pay or lose their job, the person paying the child support might have to pay more. If they become voluntarily early retired, though, then that's not going to be a substantial change in circumstances. They can't just choose not to work anymore. They have to try to be employed. Another big one is the needs of the children. So if the needs of the children increase, let's say they need to go to this private school because they're very gifted, then the court's going to look at both the increase in the need of the children and also the financial situation of each of those parents to meet that need in determining whether the child support order is going to be increased in that situation. One thing that's not a basis in and of itself for increasing child support is an increase in the cost of living or inflation. So just because the standard cost of living has gone up or inflation has occurred, that's not enough to say there's been a substantial change in circumstances. However, if the person receiving child support can show that based on this inflation or increased cost of living, his or her actual expenses for the care of the child have gone up on an individualized basis, then that might be a substantial change in circumstances. So they can't use statistics, but they have to show that their actual cost of living has gone up. Remarriage of either party in and of itself isn't a substantial change in circumstances, but if you can show similarly with the cost of living on an individualized basis that based on the new family, either maybe the spouse of the new family has a large income or you have increased parental obligations or other expenses that factor into your ability to pay, then that might be a substantial change in circumstances. And when we talk about the financial situation of the parties, we're not just looking at changes of income, we're also looking at changes in expenses. Like, for example, if you have a new mortgage that you have to be paying on and it's reasonable, or if your maintenance payment terminates and now you have more money to spend, changes in expenses can be a change in circumstances as well. The emancipation of the child is one that people don't think about, but if the child leaves the home and decides to be financially independent, even if they're under the age of 18, that's a basis for terminating child support. But again, unless it's the last child reaching the age of 18, you can't just terminate child support on your own. You have to go into court to have that done. I want to say that it's a flexible scale, so there's going to be a lot of people that are going to be trying to go into court after July 1st, 2017 to show a change in circumstances in order to have the new law applied. So you should definitely talk to an attorney to see, if you're not in one of these categories, whether your personal financial circumstances might rise to the level that you might be able to have your child support modified. Because there's no real hard, fast rule on what constitutes a change in circumstances. We're just going based on case law. And if you go to learn-about-law.com, we have a much deeper description of what the case law has said about each of these different circumstances. So thanks so much for listening. I want to thank Tom Weiler for doing our videography. If you like what he's doing for me and you'd like a video made for yourself, you can go to weilerstudios.com. If you'd like to schedule initial consultations about child support, divorce, family law, or almost any other area of law, we can help at O'Flaherty Law. You can call us at 630-324-6666 to schedule an initial consultation. Go to learn-about-law.com to see more podcasts, videos, and articles about almost every legal subject. And I would really recommend you check out our article about the changes that are coming in 2017 to child support laws. And also, you can check out my podcast and video blog for business owners at seizeyourbusiness.com. Thanks so much for listening.